Welcome to Part 5 of the Cedalius Group series on the Fair Credit Reporting Act, Teamwork in Employment Background Screening. So far, we have explored nearly every aspect of the Fair Credit Reporting Act, or FCRA. Its history, the laws that have helped to shape it, the terminology used to discuss the FCRA, the obligations of the employer as it relates to background screening, and the rights of the applicant screened. Now it's time to move into the final installment of our series to learn how the Consumer Reporting Agency, or CRA, must perform under the rules and regulations of the FCRA. Ready? Let's get started. Under the Fair Credit Reporting Act, CRAs have 5 essential duties. First, they must maintain reasonable procedures to assure the maximum possible accuracy. This does not mean that potentially inaccurate information results in a violation. It means that the CRA has a responsibility to ensure that established reasonable procedures were used to report the information. If an inaccuracy is found, the consumer has to prove the inaccuracy as well as the CRA's failure to follow reasonable procedures. CRAs must make sure when using public record data that they notify the consumer that the information is being reported or maintain strict procedures to ensure the public record information is complete and up to date. The definitions of reasonable procedures and strict procedures are still fodder for lawsuits, so it is imperative for CRAs to have clear policies in their reporting process. Second, CRAs are required to provide consumer reports to only those with a permissible purpose. Examples of such a purpose would be for employment, in response to a credit transaction, or for insurance underwriting, among others. Simple curiosity is not a permissible purpose under the FCRA. No, you cannot conduct a background check on your neighbor through a third-party background screening company just because he doesn't keep his grass cut short enough. You also cannot conduct a background check when in litigation with someone or for most marketing situations. In fact, CRAs are required to maintain reasonable procedures to ensure only entities with a permissible purpose are able to obtain consumer reports. These reasonable procedures may include site visits, verifying business licenses, checking references, and examining public information about the entity. A hot topic in litigation in this area includes the topic of certification, in which the entity is required to certify that they will use the report for the stated permissible purpose and for nothing else. Many CRAs now include a certification process with each search conducted to help avoid problems in this area. This is an especially sensitive requirement as violations could result in criminal charges. Third, CRAs must conduct thorough reinvestigations in the event of a consumer dispute. Consumers have the right to dispute information in their reports. It is the duty of the CRA to make every reasonable effort to determine the validity of the original results. As the FTC stated in 2011, a CRA responding to a dispute must make a good faith effort to determine the accuracy of the disputed item or items. Sometimes evidence submitted by the consumer on its face will make it clear that an item is inaccurate or incomplete. In other cases, the CRA must conduct a reasonable investigation that, at a minimum, would include checking with the original sources or other reliable sources of the disputed information. Depending on the nature of the dispute, investigation and verification may require more than simply asking the original source of the disputed information the same question and receiving the same answer. The reinvestigation process has multiple steps stipulated by the FCRA. They are: the reinvestigation must be completed within 30 days. It will either need to be verified during this time, corrected, or deleted from the file. The CRA is required to consider any information provided by the consumer. The CRA can terminate the reinvestigation if the dispute is deemed frivolous. Inaccurate information must be promptly deleted. The CRA must notify the consumer with the results. Fourth, CRAs must make all required disclosures to the consumer whose data is being gathered. This generally happens at the employer level who is then required to certify to the CRA that such disclosures have been made to the applicant. Beyond the initial disclosure, however, the consumer is entitled to see what is in their file. CRAs are required to provide the following: all information in the consumer's file, identification of all sources of information provided except sources used for investigative consumer reports, the identity of each person who has received a copy of the report, and a summary of rights under the FCRA. And finally, CRAs have the duty to properly dispose of consumer information via shredding, burning, or pulverizing. This disposal requirement also applies to electronic data. It is also important to note that many states have their own FCRA laws on the books, and where the state law is stricter than the federal law, the state law prevails. For example, in Kentucky, CRAs are not permitted to report any information against a consumer regarding charges in a criminal case that did not result in a conviction. In Massachusetts, consumer reporting agencies cannot use information about arrests, convictions, or indictments more than 7 years old, unless the applicant will make more than $20,000 per year. And in California and Nevada, the use of sex offender registries is forbidden for employment and other purposes. Even as we speak, states continue to develop new laws and stipulations that regulate the CRA's processes and responsibilities. The FCRA is a complex tool designed to protect consumers and employers alike, and it is important that everyone affected by the law has a good understanding of their rights and obligations. As an accredited member of the National Association of Professional Background Screeners and active member of the association, the Cedalius Group is committed to consumers, employers, and the industry overall. We hope that you have found our video series on the FCRA to be helpful and informative. The Cedalius Group is committed to educating all participants involved in the background screening process. Remember, this information is provided to you for educational purposes only. Always consult with your legal counsel regarding your background screening processes to ensure compliance. We are the Cedalius Group, the employment background screening provider you can trust.